Hi, it's Tony here again from Estate Planning Solutions. Our last video we covered binding death benefit nominations, and I recommended to you that you go and do some checking on your own circumstances to see whether it's all in order, and hopefully you've done that and hopefully it's all good. This week we're going to cover the topic of, is an electronic will a will? And under the Succession Act it can be, but we're going to look at a particular case study, and it's called Mahlo, M-A-H-L-O, versus Heir, H-E-H-I-R. And again, you may wish to go and download that yourself and have a read. But in essence, the situation in this particular case highlights, again, to do everything correctly or ends up in the courtroom, which is costs and distress and decisions being made outside your control that may not favour you or your family. So in this case, the lady died, and apparently 2 weeks before she passed away, she left a will typed up on a home computer, and in that she'd appointed her brother as executor. She left gifts to her parents and the balance of the estate to her children. But 3 months prior to that, she'd done a written will where she appointed her ex de facto as executor and beneficiary of her estate. Now, she'd discussed with her family that the relationship had finished with her de facto, and so now the time came to read the will. The children went to court and asked the court to accept the electronic will that she'd left as the last will. So much discussion took place, as you can imagine, much time, distress and costs, and in the end it was determined that it was possible that somebody in the family had constructed this will electronically because it hadn't been signed. More discussion took place, and the court formed the view that this lady had enough knowledge to know that she probably would have had to print it off and sign it. And so then they looked at what's called testamentary intention. Long and short of it all, the court let the original will, which was done 3 months before, be the will that was to be used in the distribution of the lady's assets, and the children and the family missed out. So the ex de facto became the executor and beneficiary of the estate. The point about today is, yes, we're living in an internet and electronic world, but again, doing your will and estate planning properly is not to be done electronically without some specialist assistance. So you can't set up your affairs to leave it to the courtroom. That arena is one that has to be avoided, because once you enter it, not only is it costly, there's no control. The court rules, and you have to follow the rules of the court. So have a look at that one and give that some thought as well. And until next time, good luck.